Hello and welcome to Media7. I'm Russell Brown. In this week's program we'll look at the Search and Surveillance Bill and what it might mean for the Fourth Estate. But first, a certain diplomatic dance was all the rage in Wellington last week and we thought it deserved a song.
Good evening. Well, I'm at the official residence of the Prime Minister where he's invited Hillary Clinton to a barbecue in the great New Zealand tradition. And that sort of intimacy and friendship is probably appropriate today.
You're the top. You're the Colosseum.
You're the top. You're the Louvre Museum. You're a melody from a symphony by Strauss.
You're a Bendel bonnet, a Shakespeare sonnet. You're Mickey Mouse.
You're a turkey dinner. You're the time
of the Derby winner.
I'm a toy balloon that's fated soon to pop.
But if, baby, I'm the bottom,
oh, baby, you're the top.
Thanks to Cole Porter there, because any man who can rhyme Mahatma Gandhi with Napoleon Brandy deserves a nod. Now, in the recent show, we looked at the extraordinary powers exercised by the Serious Fraud Office in demanding evidence from a journalist at the National Business Review. The point was made that a police investigation would not have those powers. Well, not so fast. The controversial Search and Surveillance Bill has been significantly pared back by the Justice Select Committee, but key features remain. The right to silence is withdrawn in some circumstances, and it will be an offence, punishable by up to a year's jail, to refuse to hand over information relating to certain serious crimes. Should we be worried? I'm joined by three men who say they are. Labor member of the committee and Shadow Attorney General, David Parker. New Zealand Herald editor and chair of the Commonwealth Press Union's Media Freedom Committee, Tim Murphy, and Dominion Post investigative editor, Phil Kitchen. Welcome to you all, gentlemen. Now, David Parker, you and the Greens expressed a minority view in the Select Committee report. This was Labor's bill in the first instance, wasn't it? What's changed?
Well, the form that it's come to Select Committee wasn't Labor's bill. There's a bit of a complex background to this. The Serious Fraud Office has been the only arm of the state that's had these incursions, if you like, into the right to silence through being able to require people to produce documents or answer questions through production orders and examination orders. And the practice has become a little entrenched in the Serious Fraud Office that they've used these powers as their normal means of investigative technique rather than save them for the rare occasion when they perhaps are appropriately used. And when we were in government, we were looking at bringing the Serious Fraud Office into the organised crime unit in the police. So it would be a serious organised crime and serious fraud unit. And the Law Commission initially recommended, because of the overuse of these powers by the Serious Fraud Office, that they be abolished completely and not brought forward into the new organisation. There was a public backlash against that. And at the time I came up to Auckland with the approval of my cabinet colleagues and went to see various Queen's Counsel who were active in the serious fraud space, both as prosecution counsel and defence counsel, and they all said without exception that the Serious Fraud Office powers were being overused, but all but one also said that we were being a bit naive if we didn't think they were necessary sometimes. So where Cabinet got to under our government was that we should carry forward a constrained version of that power into the new agency, but constrain its use and put a few more protections around it. Now we then faced with the decision of if that was justified for serious fraud, how did we tell New Zealanders that it wasn't justified in respect of some of the more pernicious organised crime? Where we got to as a cabinet was that it was appropriate to confer a limited version of this power upon both the police and the Serious Fraud Office in this new unit. Now, what then happened was that the now government campaigned on not doing away with the Serious Fraud Office. So that didn't come into the police, but they carried forward this idea that we confer a narrowed version of this power upon the police. And it is fair to say that what's proposed is a narrowed version of what is with the Serious Fraud Office, but what's gone wrong in that process, as has been highlighted by the current NBR case, is that because the Serious Fraud Office powers haven't been in the frame, they haven't tidied that up at the same time.
We'll get to the NBR in a moment, but it might be useful for you to explain to us what production and examination orders are, because they are at the very centre of this issue, aren't they?
Yeah, they are. A production order is an order that currently can be given by the Serious Fraud Office and is proposed to be given via warrant from a judge by the police to a person requiring them to hand over documents. you might be asked for something quite specific, and you've got to search the massive information and provide what is set out in the production order. So that's production orders. And examination orders, there's a requirement for you to answer questions, which you don't normally have. It abrogates the right to silence in those situations. Now, I must emphasise that there are protections around this that are provided in the new bill that aren't there in respect to the Serious Fraud Office. And people might say there should be a few more protections, but the new protections include having to get a warrant from a judge. At the moment, it's done by the
Which the SFO doesn't?
Can do it by way of Internal Administrative Act, which is not good enough. In addition, there are rights to certain claims of privilege in respect of the police process, which aren't there in respect of the Serious Fraud Office. And so we think that this, and we've been trying to get the government to say we should tidy up these Serious Fraud Office powers.
This claim of privilege is an important issue, because we contacted the Minister's office, and the statement we've got back basically says no cause for alarm. A journalist may prevent an item from being searched by claiming that it is subject to journalistic privilege, and things then stop until a judge decides whether that's valid or not. Surely that is a degree of protection.
Oh, it most certainly is. But one of the points that we've been making is that this is the opportunity to tidy up the Serious Fraud Office powers. And
we'll get to that too. But I want to go to Tim with this. I think when our researcher spoke to you, you expressed concern that this took away what the media gained with the Evidence Act 2006. Very clearly from the Minister's office, the message is the Evidence Act still applies, it's still there. Are you somewhat reassured by that?
I am, and I was also reassured by the chairman of the committee having said similarly that the media concerns will be listened to. But our concern is that it's one more lever. If it's just the same as the search warrant provision, why have it? Justifying it because the Serious Fraud Office has this power, therefore why not give it to the police? It doesn't stack up.
So yours is an objection as much on principle as you know, with regard to practical effects of what's being done here?
Absolutely, although there can be practical effects. What happens here is it's front-loaded. If they want a search warrant, they go to a judge, argue it, come with a search warrant, and we can then say, we have a privilege and we're not going to act on this warrant for you, and then we go back to a judge. This way, they go to a judge, or in production orders, not to a judge necessarily, to a justice of the peace, and they're often busy, untrained, or at least unprofessional judicial officers, and also registrars, so court staff.
So the bar isn't strictly a judicial one, is it?
Not for production orders. For examination orders it is. That's the right to silence one. And from our point of view, front-loading it, allowing them to get an order that if you don't accept or abide by, you are automatically in breach, is a real worry. And I don't think there is a need for it, if there is, for serious offenders and for crimes of complex organised crime and so on. It shouldn't, not just the media, it shouldn't also apply to bystanders. You know, your flatmate is involved in some kind of drug crime. Under this examination order process, you, the flatmate, must talk. And that hasn't happened before. That person may not have privilege either.
Phil Kitchen, you said earlier this week that you would go to jail rather than comply with such an order. Is it that serious?
Yes, it is. I mean, I think the question that journalists have to ask themselves now is, because there is a dilution of, you know, as Tim was saying, this is diluting it. It's giving the police some extra powers. And the question that any journalist needs to ask themselves is, if you're going to give a source a guarantee of anonymity and you're going to protect that source, you have to be prepared to go to jail. Otherwise, don't give it.
And you effectively give that guarantee to your sources now?
I usually talk through, depending on the significance of the information that a source is going to provide to me, I talk them through the existing legislation, which is that I say I could end up going to being in front of a judge, and a judge might say, sorry, we think that the adverse effects of this on your source are less than the public interest, so therefore we're going to compel you to provide that information. And my starting point is I say, well, I will not provide that information if that's what you want me to do. If you feel that I need to protect you to that degree, I will not provide that information, and therefore you run the risk of going to jail. No one's saying that every journalist is going to be sent to jail. But in some cases, people will say, well, of course I wouldn't want you to go to jail. In other cases, people say, well, yeah, sorry, but that's how important it is to me. And whistleblowers have a big job in our society, and it's a scary job. This is only going to make it worse for them. The ability for state agencies to gather information, to watch people, to eavesdrop on people, will inevitably lead to whistleblowers thinking, hang on, you can give me all of these protections that you're talking about, but they can go and listen to this and that, and they can track back on this, that and the other, and they can find me. And that's going to make the job for a whistleblower and a journalist a whole lot harder, which will inevitably lead to more corruption, more powerful people, more powerful organisations getting away with things that they shouldn't be
And
doing.
I imagine this would be a particular issue with the agencies that have these powers, and we'll discuss that after the break, but we'll pause now and return after the break with more on what journalists should and shouldn't have to tell the authorities.